So I have to tell you, I was chatting with the guys backstage, and I said, no, this is like my last stand. Because December 31st, I have to turn in the lawyer ticket for the CEO one. And I have to tell you, although I'm going to miss the lawyer one, I'm hoping it might be a little bit less stressful. After talking to them for 5 minutes, I'm so wrong. So what I want to do for just the next 5 minutes, because today's supposed to be fun, it's not supposed to be scary, is to tell you what's going on in the legal world with regard to your businesses. There are two major things I want to talk to you about. The new rules regarding teams that are coming to a business near you very, very soon, as well as a case law update. The courts are paying attention to your businesses, and we want to make sure that you're aware. So first and foremost, the Florida Real Estate Commission has enacted new rules with regard to how teams advertise. All of these slides will be available online following the program, so if you don't want to take pictures, you don't need to. Understand that as part of these rules, you don't have to have the word team in your name. But at the same time, you cannot use words that could lead a consumer to believe that you are a brokerage. So if you are operating a team currently that has the word agency, associates, brokerage, brokers, company, property, real estate, or some other word that a consumer would believe you are the broker, that is not going to be permissible. You are required to comply with these rules on or before July 1st, 2019. Now, the Real Estate Commission has not set violations yet, so we don't know exactly what the fine will be, but I assume that the first violation is going to be like a traffic ticket. The second major component of these rules has to do with the size of your team name or logo. Under the rules, it cannot appear in larger print than the name or the logo of the brokerage. Now, for any of you who are on a team and are thinking, oh my goodness, we have to rebrand, you're going to go through these rules. If you have a question, you're obviously welcome to call the legal hotline. If it's something that's vague or you think needs clarity, please email it to us. My email address will be on the screen at the end of the program. We are working personally with the Real Estate Commission to make sure that any vagueness or clarification needed, we will have addressed. We don't want this to be too burdensome for all of you. The other thing I want to talk about are two cases that the Florida Appeals Court have recently ruled on. The first one is one of my favorite cases in the last 10 years. Yes, this case excited me. It excited me for two reasons. One, it totally affirms that our real estate forums here in the state of Florida are a fantastic resource. But two, it is one of the most hilarious real estate cases I have read in a very long time. Now, some of you are saying, dear goodness, she thinks that case law is funny. No, this one really is, and here's why. The buyers in this case were attorneys. Need I say more? I always tell my husband whenever we buy anything, whatever you do not tell them what I do for a living. So what happened was they entered into a purchase contract. It was an as-is residential contract for purchase and sale for $2.85 million. This was not your mother's real estate. This was a very expensive home in Coral Gables. The initial deposit was $50,000. They had a second deposit due the last day of inspection, a mere $235,000 more. Now, here's where it got interesting. Remember the facts. It was an as-is contract. During the 10-day inspection, the buyer timely discovered that there were some problems. There were some open permits. They believed there was some permitted work they didn't tell them about. And truth be told, they started to make allegations that the sellers were not behaving well. And they emailed the seller on the last day of the inspection with all kinds of accusations. Have you ever seen one of these emails? Of course you have. Now, what's interesting is this is normally where the contract is canceled. Instead, do you know what the buyers did? They said, you know what? Even though we think that you are terrible people and you are deceiving us, here is $235,000 more to show you that we are a good sport. They did not extend the inspection period, and they did not cancel the contract. So, as I can sure you can understand, considering the relationship that they had at the time, the contract did not succeed. The purchase contract fell apart. And the best part was the buyers called and said, we've decided that because of the inspection issues, remember, after the inspection period expired, we'd like our money back. The seller said, no, you can't have your money back. So believe it or not, the sellers tried to do the right thing. They tried to do the right thing. They tried to settle it. Who are the buyers? Remember who the buyers are? They're lawyers, and they thought they were wicked smart. They spent 5 years in litigation. At the end of it, the court said, here's the deal. You are so wrong, it's ridiculous. So in addition to not awarding you any damages for the loss of your deposit, we're also going to award the sellers $850,000 in attorney's fees. But the best part for me as counsel for the realtors was what the court said about the Florida Realtors Florida Bar purchase contract. The court said this is a wealth of experience based on years of knowledge and transactions. It is there for a reason. If you read between the lines of the court decision, what the court basically said was, read your contract. Read your contract. Florida courts love contracts. So this is a fantastic decision for the Florida Realtors Florida Bar contract, but it's also a fantastic decision for all of you because it allows you to rely on the way you've all been taught to practice real estate. Days matter, dates matter, contracts matter. That is the moral of this decision. Next court case, nowhere near as much fun. This is a situation where we had a tenant who was going to lease an apartment in a fairly expensive building. The leasing agent / realtor lived in the same building. Found the tenants the property. It was going to be a 2-year lease, not a cheap lease, $7,500 a month. And at walkthrough, there were some issues. There were some problems. A lot of times, folks, we market ourselves as the center of the transaction. We say to the buyer or the seller or the prospective tenant or the landlord, you have a problem? Call me. You call me. The leasing agent in this case went way further. Instead of saying, hey, call me if you have a problem, they said, if you have a problem, I'm your guy. I will fix it. And this kept happening over and over and over. And the tenants moved in and the problems did not subside. In fact, they got worse. There were water problems. There was mold. There were children. Do you see where this is going? The children got sick. Sick children in litigation is bad. It never ends well. So in this case, obviously, the leasing agent defended, hey, it's not my property. Go sue the landlord. You know what the court said? The court said they could. But in this specific case, what they're saying is you promised as a real estate professional that you would be the responsible person. In fact, you kept writing it down to them. I will fix it. I will take personal responsibility. Well, unfortunately, there's a concept in the law called the undertaker's doctrine that says if you promise to provide services, you have to actually provide them. Now, the facts in this case are severe. It doesn't usually come down this way. This was factually driven. But folks, this is where you have to always remember, yes, you are the center of the transaction, but you are the source of the information, not the direct answer. Make sense? All right. To conclude, a couple other hot topics that we're going to put online for you that deal with copyright as well as do not call, do not text. What's old is new again. I have been literally going from one end of the state to the other talking about these for the last 5 years. I need you to read this information. In the event that you have a question, you're always welcome to call us at the legal hotline. We love talking to you. We love hearing about your issues. I want to thank the Miami Realtors for having me today. On behalf of Florida Realtors, we wish you a great day. Thank you.